Today I'm going to talk about the summaries for Chapter 3 and Chapter 4. First thing we learned about in Chapter 3 is jurisdiction. Jurisdiction is the power of a court to hear a case and render a binding decision. There are two types of jurisdictions. You have original jurisdiction and appellate jurisdiction. The original jurisdiction is the power to initially hear and decide a case, and then an appellate jurisdiction is the power to review a decision previously made by a trial court. Next, we learned about jurisdiction over persons and property. We learned about in personam jurisdiction, which grants courts the power to make decisions affecting specific persons in a case. In the case, you have two sides. You have a plaintiff and a defendant. The plaintiff is the person whose behalf the complaint is filed, and then the defendant is the person whose action is being brought upon. The plaintiff files a complaint. A complaint is a detailed statement containing the plaintiff's claim and the relief sought. Then the defendant is summoned, which a summons is an order by a court to appear before at a certain time and place and to notifies the defendant of the pending case. Next, we learned about subject matter jurisdiction, and that is a power that can be granted by law and not by the parties involved in the lawsuit. This is it happens if a judge renders a decision in a case over which the court does not have subject matter, the decision is void. We have executive federal jurisdiction. This handles cases like bankruptcy, copyrights, trademarks, patents, and claims against the U.S. government. Also, federal criminal prosecutions. Then you have the concurrent jurisdiction, and this deals with federal questions and diversity of citizenship. And then lastly, we have state courts jurisdiction, and this is all cases that are not under the executive federal jurisdiction. Uh, then we have the actors in the legal system. First, we have the attorney. It is a legal representative of the parties before the court. The qualifications to be an attorney is you have to have a law degree, pass the state bar examination, and possess a high moral character. Uh, with your attorney, you have attorney-client privilege, and this is information that is furnished by a client to an attorney in confidence, which may not be revealed by the attorney, be revealed by the attorney without the client's permission. An exception to this is if the lawyer may reveal confidential information in order to prevent a crime. Next, we have the judge. A trial court judge presides over the trial. He makes rules on all motions made in the case, decides all questions of law, rules on whether evidence is admissible, and decides the facts in the case and renders decision based on the evidence. An appellate judge serves on panels and reviews lower court cases. Uh, then we have judicial review, and that is the power to determine whether a law passed by the legislature violates the Constitution. We also have judicial restraint, which is courts should refrain from determining the constitutionally of a legislative act unless absolutely necessary. Last, we have the jury. The jury is randomly selected individuals from the geographic area in which the court is located. You have a petite jury that is of 12 citizens, and it decides on the facts at issue in a criminal case. Um, then you have the grand jury, which is 12 to 23 citizens, which are convened in private to decide whether enough evidence exists to try the defendant for a felony. Next, you have the adversarial system, which a judge hears evidence and arguments presented by both sides in the case, and he makes an objective decision based on the facts in the law as presented by each side. There are four steps in the civil litigation. You have the pretrial stage, and this is where you get the pleadings and the rules of civil procedure and depositions. A deposition is a pretrial testimony by the witness examined under oath. Under oath. Uh, Next, you have the actual trial. There's a term called voir dire, which is jury selection process in which the judge or the attorney question potential jurors to determine whether they could be an unbiased opinion in the case. Then you have a mock jury and a shadow jury. A mock jury is a group of individuals in front of whom the lawyers practice their arguments before presenting the case to the actual jury. Yeah. A shadow jury is the group of individuals who just sit in the courtroom during a trial. Uh, During the trial, you are allowed to have rebuttals. Rebuttals are brief additional arguments by the plaintiff to address any important matters brought in the defendant's closing arguments. Next, you have the appellate state, where the attorneys of both parties file briefs, and the court considers the briefs and review the record of the case and render a decision. After the appellate stage, you have a class action. You have class action cases, which involve a large group of individuals who share a common complaint against the defendant. And then lastly, we learned about the Class Action Fairness of 2005, and this sought to limit the legal fees of attorneys